Okay, so hello, good morning, everyone. Welcome all to this property conveyancing symposium this morning, right? So now it's 10 o'clock. Okay, thank you for joining us this morning. Okay, so I'm Deborah from Learning and Development Department. Okay, so before we start this session, maybe just a short introduction of this Fortis Will. Okay, so Fortis Will is one of the pioneer estate planning companies in Singapore that offers affordable and accessible estate planning and will writing services. They have written over 28,000 wills and have registered the most number of lasting power of attorney in Singapore. So today we are honored to again invite Mr. Patrick Tan from Fortis Law Corporation to share this topic on legacy planning with us. Yeah, so without further ado, okay, I will pass the floor to Patrick. Thank you. Patrick, over to you.
Hi, good morning, everyone. If you can hear me and see my slides, can you type 1 in the group chat so that I know that you can hear me and see my slides? Okay, all right, I see many ones now. So, okay, thank you very much, Orange Tea, for inviting my team and I here to share with you today's topic on legacy and advanced care planning, something very close to my heart. So I know it is a conveyancing symposium, but today I'm not going to talk so much about conveyancing. I'm going to share with you this topic called legacy planning and advanced care planning. And in a way, how this type of planning, right, can actually, or is actually related to real estate also. So if you have any questions related to this webinar, please feel free to type it into the group chat. I will try to answer all your questions if time permits, all right? So hope everyone is keeping safe. Sit back and relax and enjoy the webinar. And also remember to take action after the webinar. Okay, these are important documents that I hope that you will take action, get these documents done. And because we're not doing this for ourselves, but for our loved ones and also for our clients. So spread the word. After this webinar, share with your loved ones, your clients, your prospects about the importance of having legacy planning done. Okay. So also follow and like Fortis Law and Fortis Wills on Facebook for updates on upcoming webinars. So please like our Facebook page or LinkedIn page. We do these webinars quite often, and we would like you to attend and learn more about what we have to share. All right. So this is me, my credentials. I am the founder, CEO of the law firm Fortis Law Corporation. I've been in practice for 20 years now. I also co-founded Fortis Wills, which is the company presenting this talk. So they have kindly invited me to share with you what I know about estate planning, legacy planning. All right, so I am a practicing lawyer, of course. What do I do? So besides managing the law firm, I have a team of few lawyers with me. We do things like real estate, of course, wills, trust, probate, so on and so forth. And I am currently the legal advisor to SEAA, Singapore Estate Agents Association. I am also a CPD trainer approved by the CEA. Some of you might have attended my CPD training before. And for those who have not, I would strongly encourage you to come to one of my CPD courses. I have about, I think, 14 or 15 CPD courses out there with different training providers. So I would strongly recommend that you attend these CPD courses. As CPD cycle is coming up, it's already end of July. So I hope to see you in my CPD courses. All right. So let's start off with advanced care planning. What advanced care planning is all about. All right. And how advanced care planning can actually help in what you do. Right. So ACP is the process of planning for your future health and personal care if you become ill one day. We're not talking about minor illnesses like cough, flu, fever. We are talking about serious illnesses like coma, stroke, cancer, serious dementia. All right. So advanced care planning is a process where you put up a plan, an SOP, and tell your loved ones how you want to be looked after when you're no longer able to look after yourself, right? So this is an important part, important plan that we need to have. And it is not new. In fact, many hospitals in Singapore have been offering these services for quite a number of years now. But in the past, they only offered these services to their inpatients and usually terminally ill patients. They do not offer these services to members of the public or outpatients. But in the past couple of years, Ministry of Health has been actively promoting advanced care planning to members of the public, because they realize that it is important for everyone to plan when they are okay, than to plan when they are terminally ill. It makes a lot of sense. Later on, I will share with you, and maybe you can see for yourself that how advanced care planning can actually help in facilitating actually the transfer of properties from one to the other. So ACP is important. It is an important part of what you do, right? Besides helping your client to buy and sell a property or to rent out a property, right? It is also important for you to remind them to do advanced care planning, because if something were to happen to them, right, when they become very ill, when they are no longer able to manage the property, to sign the tenancy agreement, or to exercise the option, or to sign or to complete the conveyance process, right? You need someone who is authorized to do so on his or her behalf. This is part of advanced care planning. And then later part of the sharing, I will talk about legacy estate planning, the importance of having a will. So a will comes in only after a person has passed away. Before the person has passed away, it is advanced care planning, right? So death is the cutoff point. Before the person passes away, we talk about advanced care planning. After the person has passed away, we talk about estate planning. All right. So let's start with advanced care planning. So this ACP, right? By having this advanced care planning conversations, ACP is all about having conversations with your loved ones. These conversations will allow you to share your personal values and beliefs and explore how these values and beliefs will affect your healthcare preferences during these very difficult medical situations. And also, more importantly, to think about who among your loved ones, your spouse, your children, your brother and sister, can be your representative if you become very sick one day. Because by that time, right, you are no longer able to take care of yourself. You probably would have lost mental capacity and the ability to manage your own affairs. So it is important to think critically who among your loved ones can represent you during this period of time, all right, including signing documents. So this is not airy-fairy stuff, okay? By having this conversation with your loved ones. Later on, I will share with you what are some of the documents that you can actually do, right, under this advanced care planning framework. Now, the first document is called the ACP Workbook, Advanced Care Planning Workbook, right? This is a guidebook to help you through this process of advanced care planning. Again, it is not new. In many parts of the world, in the US, in Australia, and the UK, advanced care planning workbook is actually quite common, right? In fact, they have different versions of advanced care planning workbook. In Singapore, we also have a few versions, but there's those simple one, there's those complicated one. But basically, the objective of this workbook is to help you through this process of advanced care planning. And in this book, right, it includes a number of thought-provoking questions to help you explore the values and beliefs that will influence your healthcare decisions. So what will happen is that our advanced care facilitator, right, these are highly trained professionals. In Singapore, there are only a few trained agencies. They are trained by specialists who can help you and your clients to go through this advanced care planning process. I think less than 10 of them, right? So what they will do is that they will sit down with you and your loved ones, interview you, and ask you to basically provide answers to a number of questions. Now, these questions would include, for example, your pain threshold level, which hospital you like to go to, what kind of medical treatment would you want to receive, invasive, non-invasive treatment, so on and so forth. So these answers will be recorded in this workbook. It is usually about 2-hour session. And then this workbook will be registered online. So a few years ago, Agency of Integrated Care, which is a state board of Ministry of Health, has launched a national database where this workbook can be registered online. It is a confidential database. And what will happen is that when you become very ill, the healthcare professionals can actually extract this workbook from the database, take into account all the answers that you have written previously about your healthcare preferences, so on and so forth, and then work with your family members and come up with a care plan So the care plan will take into account all your personal preferences, your healthcare preferences, right? So the care plan will basically include what your wish list, so to speak. And on the other hand, if you have done proper financial planning, that will provide the financial resources. So on one hand, you have the money. On the other hand, you have the care plan. Your family members can then put them together and look after you holistically. This is what the Advanced Care Planning Workbook is for. Now, without this workbook, the flip side is your loved ones may not know how to look after you. Never assume that your loved ones know how to look after you. What is going on in your mind, right? We are not talking about giving you like cough syrup, Panadol, and all this. We're talking about serious illnesses, you know, looking after you when you have cancer, when you have renal failure, so on and so forth. There is a high likelihood that your loved ones may not know how to look after you, right? Because these are the things that our loved ones are not trained in, right? In fact, these are the things that we don't even talk about on a day-to-day basis, right? We talk about where we like to go for holiday, what dinner would we like to eat, but we don't talk about things like this, right? That when I am very sick, when I have serious dementia, when I suffer a stroke, do you know how to look after me? But yet these are the things that we need to talk about, right? Because there is a good chance that we will go through this stage, you know, before we pass away, right? This could be weeks, if not months, if not years. It is important that our family members know how we want to be looked after, right? If we have a plan, an advanced care planning workbook, in a sense, it will elevate burden on their shoulder also, on our loved one's shoulder, because the last thing we want is for our loved ones to actually quarrel over how to look after us, right? Your spouse will have some idea how to look after you. Your children will have their own idea. So the last thing we want is for your loved ones to quarrel over how to look after you. So do not let this thing happen. Come up with a SOP yourself. Come up with a plan yourself, right? Come up with the workbook yourself, and let your loved ones know how you want to be looked after. All right? Do not leave it to chance. Do not assume that they will know how to look after you. So this is the Advanced Care Planning Workbook. Very important. Now, the second document under the Advanced Care Planning Framework is this thing called LPA, Lasting Power Attorney. In Mandarin, we call it 持久授权书. Very important document as well. This document came into Singapore in 2010. So I did mine in 2011. If you have not done yours, or if your client has not done theirs, please advise them to do it ASAP. Now, for Singaporeans, right, the government has waived registration fee up to August 2020. So you have less than 2 weeks to do it. After that, the government may reintroduce registration fee of $75. So you have to pay extra $75 to do the lasting power attorney. So enjoy the registration fee waiver while you can, right? By August 2020, they may reintroduce the registration fee. All right. So lasting power of attorney is a legal document that allows you to appoint someone you trust called a donee to make certain important decisions on your behalf when you have lost mental capacity and the ability to manage your own affairs. All right. It is a legal document that authorizes someone you trust. And this someone you trust, this person called a donee, will be fully authorized to make certain important decisions, including signing certain documents, such as your OTP, your TA, and all this. So it is an extremely efficient and powerful document that really there is no reason why you should not have one. All right. So this is the LPA, right? It is a legal document that allows your client or yourself to plan ahead that in the event if you were to lose mental capacity due to whatever medical condition, right? Who do you trust to appoint, called your donee, to take care of you, to make decisions on your behalf, to look after your properties for you, right? Don't just, if you don't have, imagine if your client or yourself were to lose mental capacity, who is going to manage the property? Who is going to sign the OTP, right? Who is going to basically sign the TA? That may create a lot of problem, you know, right? If you don't have an LPA, the next of kin will have to get a lawyer like me to apply to court for a court order called deputyship, you know, right? So it is either you have an LPA or you don't have an LPA. If you don't have an LPA, we need to go to court and make the application. And I charge easily $10,000, you know, for the application. And it takes about 6 months to 9 months to get it. And there is no guarantee that the next of kin can get the court order. But if you have an LPA, lasting power attorney, then there is no need to get any court order to make any application to the court. With the LPA, the donee can come in straight away, take over the donor's life. and make decisions in the interest of the donor. All right. There are essentially two types of LPA forms, Form 1 and Form 2. I did Form 1 myself because it is most of my clients did Form 1 because it is a easy to use form, prescribed form, standard form, with very few limitations under the Mental Capacity Act, which is the law governing this lasting power of attorney. Form 2 is a blank canvas. It is a customizable form. It grants more specific powers and restrictions to your donee. And under Form 2, you can even appoint trust companies to be your donee. So for example, if you have special instructions, for example, your donee can only withdraw money from UOB bank and not your DBS bank account, such special instructions you have to do Form 2. Because Form 1 does not have the ability to actually customize, right? So if there is really no need to customize, then Form 1 is really sufficient. And under Form 1, you can appoint also up to 3 donees, primary donee 1, primary donee 2, and a replacement donee. But if you need 5 donees for whatever reason to look after you, then you have to do Form 2. All right. So essentially, there are only these 2 forms, Form 1, Form 2. Right? Both forms will need to be registered with the Office of the Public Guardian in order for it to be effective. Now, registration takes about a month or less. You can actually use your Symposium and log in and check the registration status. Once registered, your LPA becomes effective immediately. The only thing we need to wait is for you to lose mental capacity, and then your donee can use the LPA immediately already. Now, what to consider when making a lasting power of attorney? Of course, who to appoint as your donee and a replacement donee, right? Appoint carefully. Most of my clients would appoint their spouse, their next of kin, or the children. Very seldom they would appoint outsiders. And your donee must be at least 21 years old, cannot be a bankrupt, and most importantly, someone who loves you a lot. All right? So you can appoint your son to be the primary donee 1, your daughter to be the primary donee 2, and then maybe your another child to be your replacement donee. Or in my case, I only have 1 donee, my wife. I didn't even have donee 2. I didn't even have a replacement donee. Personally, I feel that if this person know how to look after you, 1 is enough. Sometimes too many donees also may be problematic, right? So what kind of powers can you grant to your donee under LPA? So basically, if you have done the LPA, right, you give your donee 2 types of decision-making capabilities in terms of personal welfare decisions and property and affairs decisions. So your donee would have power, the authority to make decisions related to these 2 categories of matters. Personal welfare would include where you stay, who you stay with, what you eat, what you wear, which hospital to go to, what social activities to take part in, so on and so forth. So it is a very wide-ranging decisions that your donee is authorized to make. And property and affairs. So this may concern you more. Property and assets. So the donee would have the power to buy and sell the property, rent out the property, right? Deposit, withdraw money from the bank accounts, claim insurance, claim CPF, pay taxes. So the donee would also have the power to do all of these things. So as you can see by now, if you have an LPA, it basically facilitates the transfer or the management of real estate on behalf of the donor when the donor is no longer in a position to do so. So this means that actually it is a very good conversation starter that you can have with your client, You can ask them, say, hey, by the way, have you done an LPA, right? Then your client may ask you, what's an LPA? You say LPA actually helps, in terms of managing your properties, real estate and all this. Because in case touch wood, if you were to lose mental capacity, right, due to a stroke or what, then basically your donee can continue to manage your properties, your real estate investments for you. So there is no disruption, right? So you can ensure continuity because you have an LPA. So it is a very good conversation starter that you can use with your clients, all right? So as you can see by now, your donee has wide-ranging powers under the LPA to make decisions related to these 2 categories of matters. However, having said that, there are certain safeguards put in place by the law, right? There is a general restriction that says that the donee cannot make a decision on your behalf if he or she knows or has reasonable grounds to believe that the donor does not lack capacity to make that decision. So what this means is that basically your donee's powers under the LPA will stop as soon as you have regained mental capacity, right? You make your own decision. This is to protect you. There are also other specific restrictions under the law, although the list is not exhaustive. Your donee, although your donee has wide-ranging powers, your donee has no power to sign your will, make or revoke your CPF or insurance nominations, cannot change your religion, cannot change your gender, and cannot marry or divorce you away, right? So these are safeguards put in place by the law to protect the donor. And also there is one decision that your donee cannot do is life and death. Your donee has no power to decide whether you live or you die, right? That decision comes under this third document under the Advanced Care Planning Framework, which is called Advanced Medical Directive, which I will explain in a later while. Now, who should make an LPA? Basically, any Singapore citizens above 21 years old and above, as long as he or she is of sound mind, can make an LPA. Permanent residents, foreigners with assets in Singapore, such as businesses, properties, bank accounts, shares, can and should also make an LPA. However, for PR and foreigners, they do not enjoy registration fee waiver, right? Registration fee waiver only applies to Singaporeans until next month, August 2020, okay? For PR and foreigners, they have to pay registration fees. So, Advanced Medical Directive. This is the third document that I want to share with you under this Advanced Care Planning Framework. It is also a legal document that can only be done by a doctor, right? This is to tell the doctor that you do not want any life-sustaining treatment to prolong your life in the event that you become terminally ill and unconscious where death is imminent, right? So in Singapore, it is illegal to perform euthanasia. Euthanasia is illegal in Singapore, unlike in the Netherlands, in France, in Switzerland, and in some states in the US where euthanasia is legal. In Singapore, it is illegal. But what is permitted is Advanced Medical Directive, right? Which is to tell the doctor you do not want any life support, okay? So now for a moment, think about this. If you or your client is ever at this stage, right? Your quality of life is quite low. You're on the brink of death. You need to think about whether you want to prolong your life artificially, right? By using life-sustaining treatment. Now, life-sustaining treatment is not cheap, right? Medical treatment is not free in Singapore. I mean, aircon at your home now is free. Or oxygen in your house now is free, but oxygen in the hospital is not free. Every time they pump air into your lungs, it costs money. The cheapest life-sustaining treatment I know in a public hospital can cost up to $500 a day. A day. In a private hospital, it can go up to a few $1,000s a day. Now, do you want all this money to be spent on prolonging your life artificially? Or do you want to save this money for your children, for your loved ones, right? You have to make a decision yourself. Otherwise, your family may sell their properties, you know, right? All the real estate investment to sell to put the money into life-sustaining treatment to prolong your life because they do not know. I mean, which family members would actually want to end their parents' life, right? So they would do their best to prolong your life, hoping for a miracle, right? That you will wake up. Now, so think about it. Do you want that to happen? And number two, by the time you reach this stage, your quality of life will be quite low, to be honest, right? But it will not be you who suffer alone. Your whole family will suffer with you because they will come to the hospital every day to visit you, right? Praying for you, hoping that a miracle will happen, right? Thirdly, do you think there's any dignity in this to be hooked up to a life-sustaining treatment? One life-sustaining treatment is that they'll open a hole in your throat here and put a respirator through and pump oxygen in, you know. How I know this? Because my father went through this, you see, before he died in 2013. So I know how all these things work, right? Because my father went through this for 1 year, you know, before he passed away in SICU in the Singapore General Hospital in February 2013, right? So my father did not do AMD. So nobody, when the doctor told us to bring him home and let him die, nobody could make that decision. And believe me, it wasn't an easy decision to make. Right? We're not talking about bringing my father home, go and eat steamboat, you know, eat Hai Di Lao. You know. I mean, we are talking about bringing my father home and die. You know, I always remember the conversation we had at SGH that Saturday afternoon. Right? So my whole family was in shock, you know, when we heard that, what the doctor said. And because my father didn't do an AMD, he probably thought that, you know, family members, we could sit down and decide, but we couldn't. How to decide on things like this? Right? It wasn't easy. So I kept my father there in the hospital for another 8 months before he finally passed away. And during the 8 months, it wasn't easy at all. Every night I will visit my father after my work. And besides that, my finances were drained, right? I spent all my savings on keeping him alive, hoping that a miracle will happen, that he would wake up, but he never did. He never did. So never assume that your loved ones know what you want, You have to let them know. If you do not want any life-sustaining treatment because you think that it is pointless, many of my clients think that it is pointless. They want to go home, right? Then you have to do this document, Advanced Medical Directive, let them know. Otherwise, your children may be stressed, don't know whether to do it or not. And believe me, why put this burden on their shoulder? It is not going to be an easy decision, right, for them. So who can do an AMD? Anyone above 21 years old can do an AMD as long as they are not mentally incapacitated. This document needs to be signed by 2 witnesses. Even lawyers like me cannot do it. It has to be done by a doctor. And from what I know, many doctors don't do this. But the doctors whom we work with actually provide these services. Right? His clinic is located downstairs of my office. And the other witness is usually the clinic assistant. So the witnesses cannot have any vested interest in the patient's death. And once signed, this AMD needs to be registered with the Ministry of Health, with the Registry of Advanced Medical Directive, right? So very important document, something to consider. So just to recap, there are 3 documents that you need to do or you should consider doing under Advanced Care Planning Framework: the ACP Workbook, the Lasting Power of Attorney, and the Advanced Medical Directive. Many of my clients, when they come to us, they do everything because they all agree that these are all important documents, and they also realize that these are not expensive. AMD only costs $80, and that is inclusive of the doctor's fee. LP is $250. Advanced Care Planning Workbook is only $120, thereabout. So our clients were pleasant, they're all pleasantly surprised that, how affordable that these documents are, but yet they are so important. So when a person passes away, we no longer talk about advanced care planning. There's no advanced care to talk about already, right? So if all the medical bills have been settled properly, everything has been taken care of, and there is still a nice nest egg left, then what we need to talk about is estate planning, legacy planning, right? This is when we talk about whether the deceased person has a will, all right? If there is a will, his assets, most of his assets, including his real estate, can be distributed and administered in accordance with his will. If there is no will, then in Singapore, we have this law called the Intestate Succession Act. This law will basically dictate who will get your hard-earned money, your real estate. Now, for a moment, think about this. You let the law decide for you who should get your money, who should get your property. You might as well let me decide for you. It doesn't make any sense. Why? Because the law doesn't know who loves you, who is important to you, who needs your help, who wants your property, right? The law probably doesn't care. In this law, right, there is a formula. We call it the distribution rules. These rules will basically set out, who should benefit, who should inherit your real estate. And it may or may not work, And I do this for a living. I've seen many problems arising because of not having a will, right? Properties that would otherwise not be sold ended up being sold and the money distributed, right? So there was no planning done by the parents, and it resulted in many problems. Now, in the past, when I first started practice as a lawyer, right, there were many reasons why people did not want to have a will. Superstition, they found it too expensive, and they believed that for some reason only the rich, the millionaires can do a will. But let me assure you, there's no law that says you need to be rich. You need to own a good class bungalow before you can make a will, right? Right? Everyone should have a will. We have done 28 to 30,000 wills. I've written will for the very poor. I've written wills for the very rich, right? HDB is a substantial asset, costs a few $100,000 at least. HDB can be willed away too. Another common mistake, thinking about that your loved ones know what to do, nothing will happen to you, at least not so soon. They like to procrastinate. Thankfully, these reasons were no longer true nowadays. That's why many people are coming forward to have their will done. All right. So please get it sorted out. All right. Nowadays, a lot of people are coming forward to have their wills done. I did my first will when I was 28 years old. Now I'm 47. So when I was 28, fresh out of law school, I already made my first will. It took me less than 10 minutes, right? So now I've changed my wills 4 times. So making a will can be changed. You don't have to worry that once you make a will, everything is stuck. You cannot update, cannot review, cannot change. It can be changed. It can be updated, all right? So your will only comes in when you pass away. When you're alive, your will has no effect. Unlike the LPA, your LPA comes in when you're alive, when you have lost mental capacity. The will, even if you were to have one this afternoon, will not come into effect unless you have passed away. All right. So what exactly is a will, right? But before I do that, I just want to say that, making a will, just like your LPA, is never just about you. It is about your loved ones. Because making a will is an act of responsibility, it's an act of love. It is about providing for your spouse, for your children. It's never about you. Because like I said earlier, by the time your will comes into effect, you're dead anyway. It is never about you. All right, it is about your loved ones. Right? So you have provided your spouse, your children with a roof over their head. You have provided your kids with education. You have raised them well. So doing a will is a continuation of that process. Is to let your loved ones know that if your time comes, it could come today, it could come tomorrow, right? All these hard-earned monies, all this real estate that you have invested, who will it go to, right? So it is an act of responsibility. It's an act of love. Making a will is about your loved ones. And now having a will is important, right? But you need to have proper and adequate financial planning. No point having a will written, but then you have nothing to give, also no point, right? Then your will is just a piece of paper, right? It's meaningless, right? So remember that you need to do financial planning. All your debts are settled, your housing loan, car loan, whatever loan you have get settled. So for your clients with mortgage loans, remind them to take up a mortgage insurance, Otherwise, without mortgage insurance, when they die, before the property can be transferred under the will, the bank will come in first, The bank will basically wants the entire mortgage to be settled in full. No more installment plans, So you need to let your client know that, hey, you have taken out a mortgage. You should also look into a mortgage insurance so that when something happens to you, the mortgage gets settled and your loved ones can basically inherit a loan-free property. That requires proper financial planning. Then your will work, all right? So what exactly is a will? All right. Okay, there's a question here. There is a charge if there's a change of will, of course. The charges will really depend on how minor, how complex the changes are. In my experience, the charges are not expensive, like $100, $200, $300. And what you get is a brand new will, right? There's no scribble on your old will. What you get is a brand new will, all right? So we do have many clients, they update their will every couple of years. It's quite commonly done, okay? So a will basically is a legal document, right? It cannot be verbalized. It must be in black and white, right? It states your intention, your wishes as to how you want your hard-earned money, your real estate to be administered and distributed upon your passing. That is a key document under this exercise called legacy or estate planning. All right, estate planning is a process in which you plan how you want your assets, your estate to be administered after your passing. And the will is a manifestation, it's the end product of this estate planning exercise. All right, remember, it cannot be verbalized. It must be in black and white. And why a will? Why is a will so important? Because you love and care for your family, as I mentioned, right? Because you are a responsible and sensible person. And because you get to decide who gets your hard-earned money and your investments, your real estate, after you have passed away. And also because you do not want the intestate law to decide for you who should get your assets and how should they get it, right? Other reasons would include because you can appoint this person called executors in your will. If you recall, in the LPA, the person you trust is called a donee. In a will, the person you trust to administer your will and distribute your asset is called executor. So you can consider appointing your spouse, your children as the executor also. And an executor can be a beneficiary on your will, of your will. So if you're thinking of giving your property to your spouse, you can consider appointing your spouse as the executor. But your beneficiary cannot be a witness to your will. Now, in order for your will to be valid, you need at least 2 independent witnesses, right? So let me repeat, your executor can be a beneficiary, but your beneficiary cannot be a witness. Your executor can be a beneficiary, but your beneficiary cannot be a witness, all right? Now, why is this so important? Because if you don't have a will, who's going to help you administer? Who's going to help you transfer your HDB? HDB is not going to help you transfer, right? The banks is not going to help you take out the money and give to your children, right? There may be nobody who is going to do all these things for you. And never assume that your children will volunteer. I've done many court cases involving this, where none of the children wanted to bother. I've also done many court cases when every child wanted to be the administrator, right? So when everybody wants to do is a problem, nobody wants to do is also a problem. You can avoid all this by stating in your will clearly who can be your executor, who do you want to appoint as your executor, right? That avoid the need for disputes. There's no need for dispute. I mean, that avoid disputes totally. And another reason why making a will is so important is because you love your kids and you want to appoint a guardian. If you have a will, you can appoint a guardian to look after your kids if you and your spouse were to pass away. For those with children below 21 years old, it is almost a necessity, a need, a SOP to actually appoint a guardian in your will. Like in my will, I appointed my mother. So if I die this afternoon, right, my mother will come in and co-parent my 3 children with my wife. And in my wife's will, she appointed her mother, my mother-in-law. So if both my wife and I were to die while on holiday, then the 2 grandmothers will come in and look after the kids. So it's being responsible, right? You need to plan ahead who to look after your kids. And also because you want to set up testamentary trust. This is another interesting feature. If you have a will, right, you can actually include testamentary trust in your will. For example, in my will, right, my children do not get lump sum when I die. I have set up trust in my will that says that my children can only get my money when they turn 18, 25, 30 years old. And they can only use my money for education, living, and medical expenses. In other words, they cannot use my money for shopping, for holiday, and all this nonsense. All right? So you can also do trust for real estate, right, for private properties. So you can say something like, when I die, I transfer my condominium, my good class bungalow to a trust, who can then manage the properties and rent it out. The rental income will be used to for the benefit of my children and grandchildren. You can do something like this. But by the way, HDB cannot be put in a trust, only private property can. So with a will, you can do fancy stuff like this. Without a will, you can't. And that property would have to be transferred, right? And the transfer may create problems. For example, HDB flat. What if the beneficiary already own a HDB flat? You cannot own 2. Then what happened? This HDB flat would need to be sold, which may not be the wishes of the deceased person, right? So what if you want to give, let's say, a property to a foreigner, a landed property? You can't also, because we know that foreigners cannot own landed property in Singapore unless we're talking about Sentosa Cove, right? So there are all these considerations that we need to think about. By having a will, it can actually allow us to think through this entire process and plan properly. And of course, the last reason is that because you want to avoid costly disputes, and that's the reason why you need to have a will. So these are the common reasons why so many people are coming forward to have their will done. All right. Really, I've done this talk for 15 years. I have not come across one legit reason why people should not have a will. To make changes to my will, do I have to go back to the same lawyer? You don't have to. You can actually go to different lawyers to actually change your will. All right. So what assets can you give under your will? So basically, your will can include real estate, what we call immovable property, condominiums, HDB flats, landed properties. But in Singapore only, if you have real estate overseas, you have to do a separate will. We can help you coordinate, or Fortis Wills can help you coordinate. They work with law firms around the world. So many of our clients will recognize that they have real estate investments overseas, like in Cambodia, in Malaysia, in Hong Kong, in Australia. What we will do is to get a separate will done overseas. It is becoming very common for people to have multiple wills. All right, so basically Singapore will cover Singapore assets, right? And overseas wills cover overseas assets. That is our advice to our clients. Although having said that, Singapore wills can be applied to certain assets in Commonwealth countries and common law countries. For example, if you have a bank account in the UK, our Singapore will can actually apply to that bank account in the UK. All right. Our will can also include what we call movable assets, such as monies in the bank account, stock and shares, sarong kebaya, your Rolexes, right? So your will can include many things. However, there are a few things that your will cannot include. For example, CPF monies. When a person passes away in Singapore, the CPF accounts will be closed automatically. The CPF balances, right, in the ordinary account, special account, will be handed over to the public trustee office located at Tanjong Pagar. And what the public trustee wants to see is whether you have done a CPF nomination. If you have done a CPF nomination, the entire CPF balances will be remitted to the nominee's bank account or CPF account. If there is no CPF nomination done, the CPF balances will be distributed or administered in accordance with the Intestate Succession Act, the same law that governs the distribution of your asset if you were to pass away without a will. So to put it simply, CPF board doesn't care whether you have a will or no will. They only care if you have done a CPF nomination. So please go and do your CPF nomination. And you can do this nomination online on CPF website. And the other category of assets that may not be included under your will is what we call insurance with nominations. So if you have bought insurance policies and you have nominated a beneficiary, your will not be able to include this insurance policy. However, if your insurance policy does not contain a beneficiary name, then your will can apply to this insurance payout. All right. The third category of assets that may be of relevance to you is what we call joint ownership properties or joint accounts. Now, for example, if the HDB flat is jointly owned, we all know, right? If you don't know, you should know this. You are real estate professionals, right? There are two types of joint ownership. One type is called joint tenancy. The other type is called tenancy in common. These words will appear on the title deed. So go back and check also. Joint tenancy or tenancy in common. Joint tenancy means the joint owners owns the property 100% in unison. That's what we call it. There is no demarcation of the share. The husband owns 100%, the wife owns 100%. Tenancy in common in equal share is 50-50. In unequal share could be 99-1. I'm sure some of you have heard 99-1, 80-20, this kind of things. That is tenancy in common in equal or unequal share. So there are only these two types of joint ownership. So at the point of buying a property, you can decide to buy as joint tenants or tenants in common. If you have bought the property as joint tenants, the right of survivorship will apply. As the name suggests, whoever survives becomes the sole owner. For instance, if the husband were to pass away first, right, the husband loses all the interest in the HDB flat, all right? Regardless how much he had paid for the flat, he loses all the interest in the flat. The flat now becomes the sole ownership of the wife. Now, since the husband has lost all interest in the flat, even if the husband were to have a will, his will cannot include what he does not have in the flat. The flat then falls under the wife's will. Now, conversely, if the wife were to pass away first, the wife loses all the interest in the flat. She cannot include the flat in her will because now the flat belongs to the husband solely. So to put it simply, whoever dies first, no flat lah. So try not to die first if you want the flat to be included in your will. That is called the right of survivorship. However, if the couple had purchased the property as tenants in common, if the husband or the wife were to die first, their share will not disappear. Their share in the property can be willed away. So that is the right of survivorship. All right, so be very careful. A lot of people, you know, when they buy HDB or when they buy property, they fail to understand the significance of right of survivorship. Now, this right of survivorship applies to bank accounts too, or anything that is jointly owned, right? So, for example, the will can only include monies in your own account, money in your pocket, money in your pillowcase, but cannot include money in the joint account when you die first, because when you die first, the money in the joint account belongs to the surviving joint account holder. All right. So broadly speaking, these are the three categories of assets that cannot come under your will. So your will can include only your own assets. All right. So there's also a question. Malaysian property, Malaysian lawyer to do the will for this prop. We can do Malaysian will for you, no problem. Right. So Fortis wills can also do Malaysia will, right, for your Malaysia property. Where are the wills kept? Usually our clients keep the wills themselves, but Fortis will also have this custody program. They charge, but they can keep the original will for the client in the safe, in the vault. And what they will do is that they will give a card to the client. Is there a depository or the bank where benefit can go? Some clients will actually keep it into their safe, keep in their safe deposit box with the bank, right? So how would one know if there is a will? So basically the card normally you put it together with your IC. The card will remind your next of kin that so-and-so has a will. Because when a person dies, right, the first thing that you need to surrender is your IC to the police before they issue the death certificate. So when they take out the IC, right, they will see our card. And the card will remind the next of kin that, you know, there is a will kept by Fortis wills. That is how they know. But until then, the family members do not know. So clients like this program because it gives them maximum confidentiality. They do not want to bring the will home also. They scared, you know, people ask questions and all this. Okay, what happened if I were to pass away without a will? This is the Singapore Intestate Succession Act. As you can see, these are some of the rules under this act. So if one were to pass away without a will, this act states that if you leave behind a surviving spouse without children, without parents, your beloved husbands will get everything. Actually, the law doesn't care whether you still love your husband or not. He will get everything. If you leave behind surviving spouse and children, your spouse will take half, your children will take the other half. Again, the law presumes that your spouse is more important, needs more, so take half, your children take half. Right? The law makes no distinction between your son and daughter, who loves you more, who is more filial. Right? And your poor parents get nothing. And this I totally disagree. I believe parents should get something. So if I didn't have a will, my mother will get nothing. My wife will get half, my 3 kids will get the other half. And that doesn't work for me, you see. Now, if you have no children, then your mom will get 25%, your husband will get 25%, your dad will get 25%, and your spouse will get the other 50%. So you see, your parents still rank a bit lower than your spouse. And if you are single, right, and your parents have passed away, then your brother, sister will get equal share. The law doesn't make a distinction between your sister and your brother and whether you're closer to your bro and not your sis, followed by your grandparents, uncle, aunties. And if you were to pass away without next of kin, then basically everything goes to the state, right? We call it nation building, 建国一代, right? So you look at the law here, the law is very rigid. Doesn't take into account many people, like your godson, your goddaughter, stepchildren, charities, and whatnot. And problem number 2 is that the distribution is fixed. What do you mean by 50% spouse, 50% children? And then what about your parents? What if your children already have a flat? They cannot own 2 flats. Right? So all these are real problems that need to be addressed. And unfortunately, which this law doesn't really provide an answer. So, but if you have a will, your will override this law totally. In your will, you can state, I give my property to Patrick Tan. Nobody can stop you. That is how powerful your will is. Rightly so, because we're talking about your hard-earned money, your hard-earned property. Right? We're not talking about other people's money, talking about your own asset, You must decide for yourself. And the only way to do so is with a will. Why let the law decide for you? It doesn't make any sense, So this is a good slide. I will answer your question. I know there's some questions coming in. Let me finish. The talk is coming to an end. I will answer your questions later on. This is a good slide that you can take a photo of in case you forget, whatever I've said in the past 45 minutes. So with or without a will, the difference. So as you can see, with a will, you can give your assets, your properties to whoever you wish. Without a will, you have to follow the law. And with a will, you can appoint guardians, set up trust funds, flexible. You can appoint executor. You enjoy lower legal costs later on. And without a will, these are all the problems. So there is really no reason why you shouldn't have a will. All right. So secure your loved one's future. Share this with your clients. Do not procrastinate until it is too late. There's really no reason to. And doing a will is neither troublesome nor costly. It is one of the best ways to show your love and care for your family. I mean, you and your clients have provided in many ways for them, right? Now is the time to complete this process. Do not miss the vital step. And so you see, as you can see, I mean, this slide show you the pricing of Fortis wills, right? They have a promotion for today's webinar. If you do a will and LPA, it costs $550. Right, the original price $388 for will and $300 for LPA. So actually, it's okay, affordable. And for other services, right, you can see the pricing are all listed there, right? So many of our clients find that the cost is okay, reasonable, right? So when they come to us, right, they will get everything sorted out. They'll do everything. Okay. I also want to take some time to share with you this Willpasss mobile app that Fortis Wills has developed. It's a proprietary platform. Very interesting. So this is a platform that allows affiliates or non-affiliates to download and use. Okay, it's free, right? So what this app does is that once you have signed up, please create an account. You can refer your clients or whoever who wants to write a will or do advanced care planning to Fortis Wills. Then what they will do is that they will basically handle the whole case. And once it is done, right, Fortis Wills will pay a referral fee. If you are a non-affiliate, up 10% directly straight into your bank account. So when you set up this account, right, you will be asked for your bank account details, you key in, and you'll be given an account. So you can use this mobile app to check the status of your referral and the referral fee to be paid into your account. All right, so it's a very convenient platform for you in case you come across clients or anyone who actually wants to make a will or do a LPA. You can simply use this platform, key in the name and detail, the phone number, and send it. Our back end will receive the case, and we will contact the client, and they will contact the client and take them through the entire process. Once it is done, the referral fee will be paid into your account. So it is a very neat mobile app. They call it Willpasss. Okay, so please go to Android or App Store, Google Store, and download this app, Willpasss. All right, or you can also use this QR code to sign up. It's a very simple it is meant to be simple and easy to use. Okay, just refer and earn. That is the tagline, refer and earn. Because we understand that a lot of people out there, despite our outreach effort, right, there is still a good 70 to 80% of the population out there without a will, without LPA and all this. So the market is huge, you know. So, I mean, if you come across, and I think you will, right, people around you without a will or LPA, please refer them to Fortis Wills by using this mobile app. So please scan the QR code and download this app and create an account right now. It's free. The account is free. All right. Okay. And also, I have included here key contact personnel for Fortis Wills, Eileen and Sabrina. Their mobile number are here, and their email addresses as well. So contact them if you need anything. But as I said earlier, you know, all your referrals should be done through Willpasss. All right, Willpasss. You can even check the status of the case using this platform. And Fortis Wills has 2 offices. The main office located at Raffles Place. They also have a branch office located beside JQ, near the bus interchange at Jurong. Okay. All right, I've come to the end of my sharing session. I hope that you have benefited somewhat from this session. Just to recap, I've talked about advanced care planning, why advanced care planning is so important, and what are the key documents under advanced care planning, your ACP workbook, your LPA, your AMD, and also I talk about a will, right? What a will is and what can a will do for you, and how all these documents can actually relate to real estate, the management facilitation of properties. So it is not just helping your client to buy, sell, and rent property. It is also important for you to bring to their attention the need to. Law firm keeps our will. Okay, then before we close down, let's say then the will be returned. Will be returned before they close down. But if the law firm forgets to return, then they can always do a new will. Your new will always supersede your old will. All right, last call. If no further questions, I will hand it over. Back to you, Deborah.
Okay,
thank you.
Right.
Thanks, everyone.
Thank you, Patrick.
Thank you.
Yeah. So let's say any one of you, if you still have any question, you may just email to learning@orangetea.com. Then we will collect the question and then pass it to Patrick. Yeah. So thank you, everyone. Yeah. So this will be the end of the session. So thank you, Patrick, and all. Yeah. Okay.
Thank you.
See you.
Bye-bye. Bye, everyone.
Soon.
Take
Have
care.
a great
Bye-bye.
week. Have
Thank
a great
you.
week ahead. Bye-bye.
Yes. Thank you. Bye-bye.